Welcome to this special virtual presentation from the Judiciary of Trinidad and Tobago in celebration of the opening of the 2020-2021 law term. And now, our opening prayer delivered by the Right Reverend Dr. Nolly Clark, President of the Interreligious Organization of Trinidad and Tobago.
Almighty and eternal highest on high, the light of the world, the merciful, compassionate, caring, and loving God. We seek your divine presence among us this morning at the commemoration of the opening of the new law term. Bless the Chief Justice, the judges, and all connected with the administration of justice in the country. We ask you to guide and protect them all. Continue to give them the health, the strength, and the vision to do all things right to the satisfaction of our nation. Show them the path of righteousness so that they will be guided in their judgments and decisions. Bless their families and all members of staff. Father God, you are ever present in all our relationships. You are the remover of sorrow and the bestower of happiness. May your divine light continue to shine over their places of work for safety and protection, so that they could perform their duties without fear or favor. Dear God, we seek your forgiveness of any mistakes that have been made in the past. We give thanks for all that you have bestowed upon us and seek your eternal presence. Bless those who have served this administration and are not with us today. May your light continue to be with them now and in the hereafter. May we all receive comfort and solace in your love, powers, and light. We thank you now and forever. Amen, amen, amen.
Our thanks to the Interreligious Organization. To sing God Bless Our Nation, it is our pleasure to introduce Miss Precious Regis from the Scarborough Secondary School.
God bless our nation of many varied races. May we possess that common love that binds and makes us one. Let it be known around the world that we can boast of unity and take our pride in our liberty. God bless our isles of tropic beauty, a flaming point, Sienna, and the shady motel, the warm and sparkling waters that break upon our shores beat altitude that seem to tell we take a parade in our liberty. God bless all leaders, give them grace to guide, bestow on them thy judgment wise, to rule all and aright, to keep our flag of freedom high, that we may sing most lustily. We take a parade in our liberty. We take a parade in our liberty.
We are the judiciary.
We are managing change and enhancing our service delivery.
Through it all, we are working to continue to provide access to justice
Through virtual operations such as
online maintenance payments using court pay,
virtual hearings,
e-filing.
And our development continues.
We are
the judiciary.
we are
We are
the judiciary. We are the judiciary.
As we celebrate the opening of the 2020-2021 law term, it is our privilege to introduce the Honourable, the Chief Justice of Trinidad and Tobago, Mr. Justice Ivor Archie, ORTT.
Good day, fellow citizens. It gives me great pleasure to present this address to mark the opening of the 2020-2021 law term, which actually commenced 3 weeks ago. The timing and mode of presentation underscore the fact that the theme of this year's presentation, which is managing change in a rapidly changing environment, could not possibly be more apt. Of course, no discussion about change management at this time can ignore the reality that we are in the midst of a worldwide COVID-19 pandemic. but it is precisely that which provides context to the developments that I will share with you and an explanation for our ability to pivot and adapt successfully to meet current challenges. During last year's address, I said the following words, and I quote, "Challenging times bring out the best in us, and I am proud to report that the judiciary is on the cusp of a transition that will see a dramatically restructured judiciary, whose recruitment and management philosophies and processes may well be incomprehensible to those who, looking on from the outside, may not understand what we do and why we do it the way that we do it." End of quote. I could never have imagined at the time how prescient that statement would turn out to be. Before I explain why, we must begin with a clear understanding of what courts are. A court is not merely a judicial officer sitting in a courtroom. Rather, it is a complex series of interconnected, interrelated systems. Just like an iceberg, what judges, lawyers, customers, and other stakeholders see is the 10% above the water. But you may recall that it was the 90% below the surface that sunk the Titanic. We are running a judiciary, not a ministry, not private chambers, not a bar association, not a club, not a private business or another arm of the state. It is a judiciary, a court system with the myriad of systems, considerations, and complexities that are germane to such an area of governance. I visualize the judiciary as being an organism as much as it is an organization. And in that analogy, our management are the brains, our departments and divisions are organs and limbs, our processes are our circulatory and immune systems, and our people are our heart. Our ethos and our vision form our DNA. And why is that understanding important? In a quiescent environment, there is little need for change, but a rapidly changing external environment tests our survival fitness and places an evolutionary pressure on any organism. Of course, the scientifically literate will immediately point to the flaw in my analogy by reminding us that Darwinian evolution is the antithesis of intelligent design. All that I can offer by way of defense is that it is not so much about what we want to be as it is about how we want to be: flexible, agile, and relevant. Purpose dictates form, and that is why we often find ourselves at odds with those who have been conditioned to value precedent and predictability. Over the years, the judiciary has undergone several evolutionary leaps, but by far the most extensive transformation is the one that began over a decade ago and continues to this day. In order better to understand our journey, I want to take us back to the document setting out our strategic focus for 2013 to 2016 that was arrived at after intense reflection and consultation. In it, we identified our core values as excellence, commitment, accountability, integrity, and service. None of these can be maintained without a commitment to lifelong learning and continuous improvement. We did an environmental scan to identify the political, economic, social, technological, and legal trends that had potential impact on the delivery of justice. We examined our stakeholder relationships so they could be enhanced for the benefit of all. It soon became apparent that a major impediment to achieving the desired future state was the lack of administrative and financial autonomy that we have been seeking for ages. How else are we to address recruitment, retention, and employee motivation. What can we do with delay, outdated and inadequate physical plant, inadequate workforce, and delays in decision-making from an over-centralized executive that is often not cognizant or fully appreciative of our particular needs as a separate and independent arm of state? None of this is rocket science or even conceptually challenging. Indeed, the logic appeared to have been generally accepted. Permit me to quote from the 2015 budget speech of the Honorable Minister of Finance. This is what he said, and I quote, "Most importantly, consistent with our 2015 election manifesto promise to improve the efficiency of the administration of justice, we intend to give the judiciary the financial autonomy that it has asked for so many years, coupled with the ability to manage its own resources, projects, and programs, including the responsibility for procurement and construction of judicial facilities." End of quote. Acting in good faith on the Honorable Minister's statement, I requested the National Center for State Courts, the NCSC, and the United Nations Development Program, UNDP, office in Trinidad and Tobago to jointly work towards the provision of a framework that will facilitate a smooth and effective implementation of the government's stated intent. That document has been shared with those who control the purse strings since 2016, and we anxiously await its implementation. Nevertheless, as you will see during the course of this address, we have been able to achieve quite a lot with very little. I can only hope that it will drive home the point that we can be trusted to manage efficiently and effectively in the current national environment of severely strained financial resources. So, what are the critical outcomes that we seek? The first is operational excellence. This involves modernizing our core and support processes by leveraging information and communication technology, streamlining operations by utilizing bespoke case management and information systems, electronic payments, and vote books. Financial management systems that are micromanaged by public servants in the executive branch compromise our independence, undermine the separation of powers, and destroy the agility that we must maintain in order to address changes in primary legislation, rules, and the common law. Unfortunately, many of our justice sector partners continue to operate with outdated systems, procedures, and technology. Secondly, we wish to inculcate a high-performance professional culture. The public service has no discernible compensation philosophy that will allow for seamless movement between public and private sector, thereby allowing us to attract and retain competent professionals. Historically, the focus has leaned towards compensating for certification rather than demonstrated skills and competencies. The problem of centralized human resource management must be addressed. Recruitment and management of our human resource must be in our hands. We are best placed to assess and match skills and competencies to the unique requirement of jobs within our organization. That is why administrative autonomy is essential. Thirdly, the creation of a safe and productive workplace. We are continuously engaged in modernizing our infrastructure by obtaining purpose-built facilities and retrofitting existing buildings, as well as providing appropriate tools to facilitate our work. I will share some of the recent developments later on. Then we thought about nurturing strategic partnerships. We recognize that if the administration of justice is to be improved, we must encourage and manage effective communication with customers and other justice sector stakeholders, such as the police and prison services, ministries of education, social development and family services, youth development, the Attorney General and legal affairs, And of course, the DPP, Public Defenders Department, Law Association, and the Ministries of Health, Public Administration, and Digital Transformation, and the PSA. This communication must include, but not be limited to, shared information platforms and integrated processes. In this regard, I am particularly pleased to see that a deliberate focus has been placed by the executive branch on enhancing service delivery by extending the formal mandate of the Ministry of Public Administration to include digital transformation. In respect of organizational stewardship, we accept the need for accountability buttressed by vigorous performance monitoring and tight financial control. This will also require the reconstitution of our Planning and Project Management Department, which was inexplicably decimated when job standardization was forced upon us in early 2015. Against that background, I would now like to share with you some of the more notable achievements of the past year. You may recall that in last year's address, I cautioned that the ongoing restructuring and the lack of human and material resources as we repositioned would negatively impact our throughput statistics in terms of matters determined. Added to that, the unanticipated COVID-19 pandemic has required us to pivot in some areas earlier than planned. I ask you to look at our accomplishments in that light. Thankfully, most of the work was already planned and ongoing, thereby enabling us to respond quickly. Such is the nature of our DNA that has gifted us with evolutionary fitness. In order to give context to what follows, may I remind you of a previous address in which I noted that our three pillars for transformation are people, plant, and process. In keeping with the philosophy that our human resource is our most important asset, I will therefore depart from the tradition of leading off our performance appraisal with case disposal statistics and speak first to the accomplishments of the Judicial Education Institute of Trinidad and Tobago. The 2019-2020 law term started with many collaborative training initiatives between the Judicial Education Institute of Trinidad and Tobago and several of its stakeholders. These partnerships served to deliver invigorating and timely training initiatives, which were well received by all judicial officers. While the latter part of 2019 and the beginning of 2020 commenced with the usual face-to-face training delivery, March 2020 brought with it the emergence of the novel coronavirus, commonly called COVID-19. This modified not only social life as we knew it, but the training landscape as well. In the midst of this new normal, the JEITT proved itself to be highly adaptive, adopting an effective digital learning strategy. This plan allowed for all judicial training programs to be delivered online, ensuring that all judicial educators were equipped to function in the virtual world. Through this approach, and under the guidance of the Chairman, the Honorable Justice of Appeal Gideon Lucky, and the Board, value-creating efforts were delivered and learning managers adapted to this new approach to program delivery. Virtual live learning also expanded to allow for the inclusion of not only local judicial officers, but regional officers as well. The following is a summary of the training sessions delivered for 2019-2020. The total number of training sessions increased from 22 in the previous year to 54 last year. This represented an increase in training hours executed from 156 to 279, and groups of stakeholders engaged from 13 to 24, with the judicial officer reach going from 545 to 692. Training was delivered in areas as diverse as judgment writing, the art of adjudication, amendments to the Motor Vehicle and Road Traffic Act, HIV, human rights and the law, gender-sensitive adjudication, judge-alone trials, plea discussions and plea agreements, Caribbean Financial Action Task Force standards, counter-terrorism legislation and litigation, electronic filing and hearing for judicial officers and attorneys, electronic monitoring, orientation for new judicial officers, trade-based money laundering, and insolvency. Our partners who assisted with the curricula and faculty included the CFATF, the British High Commission, the National Center for State Courts, the Ministry of the Attorney General and Legal Affairs, the Ministry of National Security, CARICOM Impacts, the World Bank, and Insol International. We extend our heartfelt appreciation to all of them. We also partnered with the Office of Procurement Regulation to assist in meeting training needs to ensure their effective operationalization. I am particularly grateful for the efforts of those judicial officers who willingly volunteered their time, knowledge, and skills to be part of our faculty for many of the initiatives. By the end of this calendar year, the first update of the Consolidated Civil Proceedings Rules, also known as the CCPR 2016, since its publication in 2017, will be completed. This text has been important in offering consolidation of the existing rules contained in the CPR 1998, along with the added benefit of case law and amendments. The publication includes the original text of the Consolidated Civil Proceedings Rules 2016, together with all updates and amendments up to July 6, 2020. This updated consolidation also includes a revised index of practice directions consisting of all practice directions in force as of the date of publication. In that regard, the new requirements and enhanced procedures necessary for navigating the civil justice system in the era of technology are all contained in the CCPR. I now turn to the main part of my address, which concerns the migration of our court hearing and information management processes to electronic platforms, the new E-judiciary, as I like to call it. The judiciary continues to focus on enhancing efficiency by reducing or eliminating redundancies, waste, and errors, using technology to remove workflow bottlenecks and speed up tasks through automation. These initiatives included the following: electronic pay record cards. An electronic system was developed to replace the handwritten employees' pay record cards. The new system incorporates automatic calculations, ease of access to authorized persons, secured storage, and improved records management. Electronic maintenance cards. A database application was developed to record information captured on the maintenance cards. The system provides easier access to information and the ability to generate reports. With regard to movement of records, an application was developed to record the location and details of court records to replace manual handwritten forms. In the area of correspondence management, we also developed an application to record incoming and outgoing correspondence and the relevant actions taken. An online system for submitting requisition requests and notification when items are ready for collection was also brought into operation. Then there was the non-criminal register, which is an application that records non-criminal matters at the district courts, formerly known as magistrates' courts, with task generation notifications and document generation built in. And finally, there was the e-vote book, which is being implemented in place of the manual process. This system will keep track of expenditure. I will expand on some of these later on. The next area that I wish to address is the management of court proceedings virtually. The declaration of COVID-19 as a global pandemic required us to find innovative ways to deliver all services. In order to keep the justice system going as the country adhered to lockdown measures and social distancing, e-initiatives that had been developed and were optional became essential. and others that were at varying stages of development were accelerated. The judiciary sought innovative and in some areas untried approaches to facilitate citizens' rights to have their matters resolved by the courts. Stakeholder engagement sessions help to inform the drafting and implementation of practice directions, guidelines, instructions, and amendments to the rules of court to govern the hearing of court matters. These included practice directions on court operations, COVID-19 emergency response, practice directions on filing by electronic means for criminal division and district criminal and traffic courts, amendments to the criminal and civil procedure rules, practice guides for electronic hearings, guidelines for the public on e-hearings, Microsoft Teams connection instructions for judicial officers and external parties, PECSIP connection guidelines for judicial officers and external parties, instructions for the use of the judiciary's summary court criminal electronic filing portal, internal procedures and processes for filing by electronic means, scheduling of virtual matters, electronic bail hearings, and virtual commissioning of documents by registrars. Early in the law term, the judiciary's Information Communications Technology or ICT unit began working on an ICT solution as an alternative to in-person hearings. The aim was to ensure that the courts, in the event of an emergency, could remain open and accessible without the barriers to accessibility that location and travel restrictions could present. The research was well advanced when the COVID-19 pandemic stay-at-home measures were implemented. Of course, video conferencing was already a component of our operations, given its initial introduction to the judiciary since 2005. Systems were in operation at several courtrooms and prison sites across Trinidad and Tobago that facilitated hearings involving stakeholders located outside of Trinidad and Tobago and/or persons who, for reasons of health, disability, security, or otherwise, were unable to physically attend court. Due to COVID-19 concerns, the court administration devised a very quick solution for prison inmates to appear virtually from the prison. We were able to acquire and convert shipping containers into fully outfitted virtual hearing rooms at the Golden Grove Remand Prison, the Maximum Security Prison, and the Eastern Regional Correctional Facility. These, in addition to previously existing systems at the Youth Transformation and Rehabilitation Center, formerly called YTC, the Frederick Street Prison, the Scarborough Prison, and the female prison at Aruca, brought the total number of virtual hearing rooms at prison or correctional facilities to 14. The technology has evolved into a virtual cloud-based meeting room to which internal and external stakeholders could connect and communicate in real time. This solution allows the judiciary's ICT staff to remotely manage and automate the processes for court-to-court and court-to-prison video connections. Inmates attend their hearings virtually from the containerized solution on the prison compound, and their counsel may either attend from the prison compound or remotely from their home, office, or other location. Members of staff have been assigned laptops and, in some instances, cell phones to support the various functions of the court under work-from-home protocols. Up to 100 devices can connect comfortably in a single hearing, and persons join from a simple web interface link which the court issues. Parties can share evidentiary material easily and communicate privately using instant chat. Guests and active participants can see all court parties connected to the hearing in a thumbnail view and the active speaker in a larger view. The latter allows everyone, including the court rapid text entry specialist who is actively transcribing the hearing, the interpreter who is translating, the judicial support officer who is capturing the log notes, the inmate, and other parties to track who is speaking at all times. The court uses this solution for remand hearings and instances where it is necessary for a person to have physical access to hardware-based video conferencing. That is, the person must be physically present. The judiciary introduced a second video conferencing platform to accommodate meetings and augment the range of court hearings for which parties' physical presence would not be necessary. We are continuously seeking to improve the service and are working towards consolidating both modalities into a single standardized platform for all virtual hearings. Judicial officers and their support staff attend remotely, and staff assist with administering the oath, sharing documents, managing the evidence, and ensuring that a digital record of the proceedings is recorded, transcribed, stored, and archived. In the virtual space, digital voice writers and CAT reporters, or computer-aided transcriptionists, convert into a written transcript the court's audio-digital recordings by listening to the court proceedings online live. Court administration also worked with the Trinidad and Tobago Police Service to ensure that persons charged with offenses could appear before the court virtually from police stations. At the court locations, establishing the virtual courtroom required no procurement of additional equipment. The solution we devised is reliant on the internet and some additional software licenses. Court staff were equipped to work from home. Training, connectivity, and background noises were issues that initially required attention, but those have been addressed. The technology, although not perfect, is working very well and is constantly being refined and expanded. With these solutions in place, the court was able to successfully address all matters scheduled for hearing at the Family and Children Civil and Criminal High Court divisions and the district courts through virtual hearings. These included 5,735 charge cases and 9,447 other hearings in criminal matters, which included district court remand hearings, trials, preliminary inquiries, bail applications, maximum sentence indications, and sentencing. Also included high court judge-alone trials, bail applications, jury trials, case management conferences, and 3 appeals. In addition, there were 237 virtual hearings from the YTRC, for a total of 15,419 virtual hearings with persons in custody. Members of the public and the media who desire a virtual seat at a hearing can contact the court office using information on the judiciary's website and would receive a link with instructions for joining the virtual hearing room. Members of the public and the media are responsible for their own technical setup and internet connectivity and are required to abide by the terms of use for hearings by electronic means. These are available on the website. In the near future, stakeholders will also be able to access information on case schedules on the website. Several attorneys have commented on the convenience offered by virtual hearings. They were pleased with their ability to appear at geographically dispersed courts on the same day, thus reducing the need to seek adjournments. They have expressed appreciation at not having to endure work downtime while waiting at a courthouse for their matters to be called, and not having to drive to a location, look for parking, walk to the courthouse, and wait, all for a 15-minute case management conference. Many attorneys who initially expressed displeasure with the arrangement have subsequently indicated their support after participating in virtual hearings. I want to speak next about the management and dissemination of court orders and documents using our bespoke solution, CourtMail. The use of CourtMail at the judiciary expanded over the 2019-2020 law term, and the need for this service intensified during the COVID-19 restrictions. The service, which was developed in-house originally as an electronic solution for communicating with and mailing court orders and notices to attorneys at law and court parties, in a fast and secure format was developed further and is now an integral tool used for electronically signing, stamping, and sealing court and other official documents. With regard to electronic stamps, signatures, and the court seal, the judiciary now uses two electronic signing solutions recognized as tamper-free and built on encryption technologies. During the lockdown, judges, registrars, and senior administrative staff use the solution to digitally sign, stamp, and dispatch notices, summonses, warrants, affidavits, declarations, and other court documents to attorneys remotely and securely, without having to interface personally. An electronic seal was also developed and used to affix documents filed electronically with the official seal, wherever appropriate. Court office staff are now able to prepare and transmit documents electronically to the judge, judicial or administrative officer for their review and signing, which they were able to do from any internet-enabled device and from any location. A domestic violence portal was also constructed to quickly dispatch orders, summonses, and documents pertinent to domestic violence to the gender-based violence unit of the Trinidad and Tobago Police Service. We also implemented a system for filing court documents electronically. Obviously, the unusual conditions brought on by the pandemic challenged our routine operations. A major concern was the safety of both staff and customers, while at the same time ensuring that the latter's right to access services was not impeded nor disrupted. Persons needing to initiate an action or having to comply with schedules for filing documents were allowed to do so via the readily accessible and convenient to use online portal. Through its e-services portal, available on the judiciary's website, attorneys at law, self-represented litigants, police officers, and other justice sector agencies have online access to court offices throughout Trinidad and Tobago to file court documents without having to commute to a court building. As at August 18th, 2,000 attorneys and pro se litigants had registered for e-services. The judiciary also provided public access kiosks at High Court locations for the convenience of members of the public who did not have online access at home. The interface contains simple and easy to follow instructions for scanning and uploading documents to the e-services portal. The placement of these kiosks helped to limit in-person interaction at counters. As of July 31st, 25,922 documents were filed electronically at court offices throughout Trinidad and Tobago. By integrating e-services with court pay and the court mail, the judiciary also allows attorneys to pay for their practicing fees electronically. Court pay allows attorneys to pay via credit card or court pay vouchers, which can be purchased at numerous locations across Trinidad and Tobago. Once payments are processed, an electronic practicing certificate is delivered to the inbox of the attorney using court mail. Up to the end of July, 290 practicing certificates had been paid for online via e-services. In order to use the e-services portal, attorneys at law must first register online via the e-services portal and must be eligible to practice as evidenced by their registration on the roll and a current practicing certificate. The system verifies attorneys' eligibility against the roll, and persons who are not in good standing are unable to file. However, the portal guides attorneys who wish to bring their practicing certificates up to date by paying their fees online through a secured gateway. Filing of documents by state agencies. In order for state agencies to file documents through the e-services portal, the judiciary designed court pay cards have been distributed to attorneys at relevant ministries and departments. With the use of these cards, they sign on and are identified as filing on behalf of the state. In its effort to manage the emergent situations brought on by the pandemic, and while waiting for the requisite approvals from the Treasury for receipt of revenue by credit cards, the judiciary, in coordination with justice system agencies, is allowing filing of documents without payment of fees for a specified period so as not to impede the right to access. When payment of fees is reactivated, attorneys in state agencies will be able to use the judiciary design cards to record the transfer of filing fees from the state agency to the judiciary. Probate lodging. This year, attorneys at law were able to submit probate lodgings for review electronically on the e-services platform. Once processed, the probate registry issues queries to the attorney or an appointment date for filing of original documents over the counter. The probate registry received and processed over 1,000 lodgings since the system launched in May 2020. With regard to the management of access to information via the website, hotlines for domestic violence, contact numbers and email accounts for persons supporting different services at court locations were published on the website. Staff received special training to operate these services remotely using computer telephony to provide information on court and support agency services, as well as assisting customers seeking applications for protection orders. Maintenance payments via court pay. Court pay is the judiciary's online system for making and receiving court payments into and out of court. The judiciary made payment of maintenance into court easier by allowing customers to convert to court pay online. The Convert to Court Pay app was included on the website. Customers simply click on it, fill out the form, and submit it. Court pay IDs are created for both the payer and the payee. Our employees then guide them through the use of the software, and immediately thereafter, both parties can begin using court pay. During the period April 18, 2020 to August 16, 2020, 3,753 payer and payee convert to court pay online applications were received. Having successfully satisfied the requirements, they can avail themselves of the convenience of making payments from anywhere at any time using their smartphone, tablet, laptop, or desktop computer. The judiciary looks forward soon to widening the network of agents where court pay top-ups may be purchased by its unbanked customers. We are working steadfastly towards making online payments for all fines and fees available early in the new law term. Electronic case management. As promised last year, rollout of the TT-JIM system has begun in the district courts. TT-JIM uses an automated system to record, track, and monitor the progress of cases from filing to disposition, accept, generate, and store case documents digitally, and produce detailed reports that assist with policy development and workload management within the court. The software seamlessly consolidates data captured from parties, including judges, judicial officers, attorneys at law, interpreters, translators, persons accused, parents of children accused, and court staff. This information is then used to prompt action, including scheduling of court appearances, tracking, retrieving, processing, and issuing reports and other documents ordered by the court, and issuing reminders and other notifications. The software improves the efficiency of case flow management, timeliness in disposition of cases, the enforcement of court orders, and the exchange of information between case parties, court staff, partner agencies, stakeholders, and the public. On the 18th of December 2019, the TT-JIM criminal module was launched in the summary court with the largest caseload, which is the Port of Spain Magistrates Court. Prior to the launch of TT-JIM, the court primarily used manual processes with minimal support from computerized systems. As a result, the majority of court documents were prepared manually, except for the generation of case sheets and the search of cases based on the name of the parties. The launch of TT-JIM resulted in transition from the use of case sheets and notebooks as the main tool and resource for case information to the utilization of an electronic court case management information system. The operationalization of TT-JIM software also created an electronic link between the court office and the courtroom. This involved a complete overhaul of the existing system, as it not only revolutionized the input and output of case information, but also how court records were stored. Apart from general case information, the system allows, among other things, for the following: automatic generation of case numbers based on the location, case type, and year, incorporation of the standards required to reflect United Nations Office on Drugs and Crime categorization of charges in conjunction with Trinidad and Tobago equivalent charges, the assignment of workflow by user and the capability to monitor the completion of assignments, and a better understanding and control of the court's workload. Staff are no longer dependent on the last or next date of hearing as a starting point to manually search for files. Case information can be obtained by an electronic search of the parties, the physical file information is accessible from the system, and the separate scanning of information for judicial officers was discontinued. Detailed case information is now available in a matter of seconds, which has led to increased productivity. Over the last 8 months, over 10,000 cases have been created in TT-JIM, and work continues behind the scenes to ensure software improvements, such as notification of associated cases and the reduction of search times. The electronically accessible case files proved to be a key resource for judicial officers and their support staff in conducting virtual hearings from remote locations. During the lockdown period, over 2,000 cases were fully integrated into the CCMS, which is a case management system, with digital files ready to be accessed virtually from another court or remote location. The lessons learned from the rollout of the system at the Port of Spain District Court were utilized to guide the implementation of the TT-JIM criminal module at the following district court locations. Point 14 commenced the first phase of rolling out TT-JIM in January of 2020 and completed it in May of 2020. The Arima District Court came on board in April 2020 and the Sangre Grande District Court in May of 2020. An enhanced version 2 of the TT-JIM criminal module is now being prepared with the capability, among other things, to follow and monitor sanctions and sentences. May 26, 2020 and following saw the partial proclamation of amendments to the Motor Vehicles and Road Traffic Act, with the intention of bringing into effect the red light and spot speed camera systems. Happily, the adoption of TT-JIM has coincided with the implementation of the new fixed penalty traffic ticketing system, enabling us to transition from manual to digitized processes, thereby creating a more efficient solution to traffic case information processing. Information for tickets issued prior to May 26, 2020 has been captured electronically for faster processing. And in an effort to address the backlog of existing unpaid fixed penalty notices at the courts, an incentive has been offered via the Miscellaneous Amendments Act 2020, which allows until November 2020 for the payment of half of the value of fixed penalty notices issued prior to May 26, 2020. Before the introduction of the new traffic system, all traffic tickets were brought before the district courts. In the new system, electronic fixed penalty tickets are issued by law enforcement officers, and the driver has the option to contest the ticket or pay their traffic fine. If the driver wishes to contest the ticket, he or she can file a notice to contest online at contest.ttlawcourts.org, within a specified time from the date that the ticket was issued. Digital transcription in a rapidly changing environment. During this fiscal year, 62 digital voice writers or court rapid text entry specialists were trained and hired, bringing the total to 84. With the use of digital voice writing, there has been faster dispositions of cases, matters transcribed live, accurate verbatim transcripts, and storage of transcripts. In terms of technological advancement and successes, the Court Reporting Services Unit, or CRSU, has been a part of a significant number of technological advancements and successes during this reporting year, including the eradication of the transcript request backlog, the commencement of confidence monitoring for all virtual courts, and assisting with judge-alone trials. The work of a court reporter remains the same, but the traditional place of work is changing. Prior to the pandemic, the Court Reporting Services Unit launched a pilot project to evaluate the feasibility of court reporters working from home, that is, e-commuting. The pilot e-commuting project, which was in place before the pandemic, helped the court reporters to make a smooth transition during this time. The CRSU saw the speedier transcribing of matters. They eradicated the old backlog totally, while also transcribing 300 matters of current work from March 2020 to June 2020. The vast majority of these were summary court matters. This was an increase of more than 60% over the baseline of matters that were transcribed when the court reporters were physically in office. Court reporters were able to produce transcripts despite being engaged with other tasks. In the virtual world, the CRSU conducts real-time reporting for Court of Appeal and High Court matters. This is accomplished with the use of computer-aided transcription reporters, or CAT reporters, digital voice writers. The CRSU also welcomed a new process for audio requests made by either internal or external stakeholders. Previously, all requests for audio were given by way of a compact disc. However, CDs were deemed archaic, as most laptops or computers no longer have ports for inserting CDs, and in any event, the information degrades after some time. As of May 2020, the production of CDs ceased, and all audio transcript requests are sent to the customer through an electronic platform via a secure link. The requester has 7 days to download and access the audio. Electronic certification. The CRSU has been working towards finalizing the e-certification of transcripts. Currently, a court reporter has to certify a transcript with the registry office at the particular court location. The e-service process involves the use of DocuSign, which, as you know, is a cloud-based electronic signature solution. As a result of this e-initiative pilot with the Supreme Court, any court reporter will be able to have their transcripts certified electronically before a registrar, assistant registrar, or district clerk of the peace. The process improves productivity by eliminating the costs for paper and printing, as well as delays in transporting the documents to the various court locations. I want to spend some time on judge-alone trials. The first judge-alone murder trial during the pandemic was completed using the audio, video, digital recording systems, and the record was archived. Court reporters were assigned to monitor the hearing and transcribe the matter, giving the court immediate access to the testimony being given. This is real-time reporting at its finest. The technology is cutting edge and, together with the integration solutions developed by our ICT staff, allows for virtual courts to run smoothly. I'd like to say a bit more about judge-alone trials. The ability of an accused person to elect trial by judge alone came with the enactment of the Miscellaneous Provisions Trial by Judge Alone Act 2017, which only came into force in February of 2019. Since its enactment, 20 accused persons have elected judge-alone trials. Even with the COVID-19 pandemic, the court was able to treat with 14 such trials. It was easier to facilitate these matters in most instances completely remotely, and in others, in particular where the identification evidence was being received, required persons were present in court with the necessary social distancing requirements. As I predicted, it appears that concerns about defendants being somehow disadvantaged are unfounded. Of the 14 matters, 3 returned guilty verdicts, 7 were found not guilty, there were 2 guilty pleas, and 2 matters were unavoidably aborted and retrials ordered. As the practicality of jury trials poses its unique challenges in the pandemic, we hope to see increased numbers of persons opting for trial by judge alone during this time and beyond. As time progresses, however, it is now obvious that the COVID-19 precautions are with us for a period far greater than originally considered, and it is therefore necessary to determine how best to proceed with jury trials in the face of the pandemic. In the light of that reality, the Criminal and Traffic Court Administration Department also commenced stakeholder discussions with the Law Association of Trinidad and Tobago, members of the Criminal Bar, the Office of the DPP, the Legal Aid and Advisory Authority, and its Public Defender's Office. A site visit to a court location was arranged to allow the representatives from the aforementioned stakeholder groups to better explore the possibilities and to develop informed decisions on the hosting of jury trials during the pandemic. Among the concerns that must be addressed going forward are, of course, the sanitization of court spaces before, during, and after hearings, and, of course, the social distancing restrictions that must be adhered to in the various zones of each courtroom, in designated jury spaces, and in waiting areas. Our protocols are based on the latest science and the Ministry of Health guidelines and legislation. Whenever it is necessary to consult with the CMO, we do not require an intermediary for that purpose. I must make the point here that everything we do in the judiciary is data-driven and based on research and the best available scientific knowledge. This sometimes puts us at odds with those who prefer to rely on intuition, anecdote, and conventional wisdom. A case in point is the notion that in virtual trials, one cannot clearly observe the witness's demeanor. Well, if you have ever done one and know how to pin the image on the screen, then you may have noticed that to the extent that demeanor may at all be relevant, the elimination of peripheral visual information enhances focus and detail. In any event, numerous studies have confirmed that even trained professionals are not significantly better than the flip of a coin in determining from demeanor whether a witness is telling the truth. We do recognize that each matter poses peculiar challenges depending on the number of accused persons, the number of attorneys in the matter, the number of witnesses, and whether witnesses were in witness protection, whether a jury was present, and what would meet the interests of justice in a particular case. Each trial, therefore, is treated as a distinct project, as indeed proper case management requires in any event. During the last term, some trials were conducted completely by electronic means, some with a blend of electronic hearing and in-person hearings, and others completely in person. So now is the time to answer the question that burns in many minds and by which, sometimes unfairly, we are often judged. How many cases did we determine? While we have been seriously impacted by the pandemic, retirements, resignations, and an incomplete appellate bench, which could only be brought up to strength by the denudation of the High Court bench, the answer is actually quite a lot. I had cautioned last year that as we transition, one would expect to see a significant reduction before the numbers picked up again. However, no one could have anticipated the devastating impact that COVID-19 has had on all aspects of national life. One must recall that practice directions were issued which suspended sittings, save and except for urgent matters or matters deemed fit for hearing by the court. We have tried, with the gracious cooperation of judicial officers and attorneys, to ameliorate the effects of the disruption by foregoing the summer vacation. But such measures can only go so far. However, while, as expected, both filing and disposition totals have generally decreased, clearance rates have remained respectable. I will merely give a brief summary, but I encourage you to peruse the very detailed statistical data in our annual report, which will be made available online. In the Court of Appeal, filings were down to 498 from 796 the previous year, while determinations were down from 577 to 184. It should be noted that of that 577 in 2018-2019, 60% or over 346 was simply dismissed for non-compliance as a result of a drive to clear off dead matters from the list. If those are discounted, the clearance rate has not suffered. In the High Court Civil Division, filings were down from 4,967 to 4,086. There was a corresponding decrease in determinations from 4,086 to 3,009. Given the reduction in the number of judges, this is quite acceptable, as the clearance rate only dropped marginally from 78% to 74% and actually represents a higher percentage per judge. Non-contentious probate. There's good news here. The reforms that are being implemented have begun to bear fruit. Even though filings dropped from 3,942 to 2,796, dispositions actually increased 22% from 2,423 to 2,958. In the family court, a 21% decrease in filings to 4,383 was accompanied by a reduction of just under 10% in dispositions to 2,555. This actually represents an improved disposition to filings ratio. It is noted that increasing comfort with virtual hearings has resulted in increased dispositions, so that while in March and April there were only 71 virtual hearings, May saw 574, June saw 914, and July saw 1,296, with increasing dispositions despite fewer adjudicators. In the children court, there was a drop in filings from 1,050 to 827, and determinations decreased from 731 to 677. This actually represents a clearance rate increase from 70% to 82%. I have left the High Court Criminal Division for last because there are some troubling issues that need to be confronted. Yes, it is true that COVID-19 has affected our ability to have jury trials. Yes, it is true that some of the judges have been elevated. But there must be a reason why only 12 indictments were filed last year. We have completely cleared up the transcription backlog in the summary courts, and committal bundles are now transmitted electronically to the office of the DPP. So it can't be that. And why are plea bargaining and MSIs not being utilized more? Nevertheless, we are chipping away at the backlog, having disposed of 97 matters. But we can take no comfort in the statistic of a clearance rate of 800%. It hides a distressing truth, which is that the criminal justice system is near collapse owing to factors beyond the judiciary's control. With regard to the district courts, formerly known as the magistracy. Comparisons with previous years are of limited value, given the rollout of the U-turn system for management of traffic matters and the full handover of matters involving children to the Children Court. This has resulted in the removal of a major portion of the caseload. Traffic matters, which took up 60% of the caseload, were essentially halved from 64,272 to 33,007. And that trend will continue as we complete the first full year of implementation by the removal of all traffic ticket payments to TT Post, with only contested tickets remaining with us. Thus, the total number of matters filed during the last term was 64,534, as opposed to the average for the previous 10-year period of 126,163. With the removal of a further 5,000 or 6,000 indictable matters when the elimination of preliminary inquiries is complete, district judges will be able to focus on their core function, which is the disposition of summary, criminal, and small civil claims and inquests. This is therefore an opportune time to rationalize and streamline the operations of the district courts. We have already begun with the reduction of magisterial districts from 12 to 3, that is, North Trinidad, South Trinidad, and Tobago. This avoids unnecessary replication of staff and services in 14 separate locations. District courts provide a wide range of services, some of which have to be managed in camera. One can readily appreciate the challenge in areas like Couva, where there's only one courtroom. Going forward and utilizing the capacity for remote access, it will be possible to have specialized locations for some services. Technology will also finally enable us to move small claims adjudication online and to provide greater access to alternative dispute resolution. We've spoken about people, we've spoken about process. I turn now to building plant. In order to support all of the aforementioned activity, we continue to engage in significant construction and refurbishment activity, incorporating the technology that drives our processes. During the last term, work began on Tower D at the waterfront. It has been delayed somewhat due to the pandemic and delayed funding, but it will be completed in a few months. I know that there is a perception that the Southland has been neglected. There's good news for you. In July this year, we turned the sod for the district court in San Fernando, which, when completed, will provide approximately 74,000 square feet of gross floor space to replace the old magistrates court on Harris Street. Funding approval has also been granted for the construction of a family court at the St. Joseph of Cluny Convent site, and construction will begin shortly. The Princess Town building is complete and will be moving in before the end of 2020. Approval for funding for repair work on the Supreme Court building in San Fernando has also been granted, and that work will begin soon. Approval for the refurbishment of the Port of Spain District Court has also been granted and the work will begin soon as well. And finally, the Tobago staff quarters will be completed during this law term, saving us thousands of dollars in hotel and rental expenses when judicial officers need to travel to or stay in Tobago. Ladies and gentlemen, as you can see, we have been very busy and very productive despite the many environmental challenges. These achievements are not the work of any particular individual. They required the collective input of the entire family that we like to call Team Judiciary. I want to publicly acknowledge all our members who have gone way beyond the minimum requirements of their jobs, sometimes at great personal sacrifice, to make it all possible. Be assured that the judiciary remains committed to its vision, which is to provide an accountable court system in which timeliness and efficiency are the hallmarks, while still protecting integrity, equality, accessibility, and attracting public trust and confidence. That is consonant with our determination to remain a high-performance professional organization. Time does not permit me to list all of our achievements and plans. Again, I invite you to read our annual report for a more comprehensive and detailed account. For now, all that remains for me is to thank you for having afforded me the courtesy of your attention. May God bless you all, and may God bless our beloved nation.
Protecting our people, bringing justice to our nation, standing firm while still being fair.